The Supreme Court just delivered a historic ruling eliminating firearm permits across all 50 states. This unprecedented judicial decision includes concealed carry licenses alongside standard purchase permits and ownership cards for every single law-abiding citizen. This ruling goes far beyond simply streamlining the basic application process or cutting down on constitutional waiting times. We are witnessing the total destruction of government permission slips regarding your fundamental Second Amendment rights across the nation. The highly restrictive permit system operating within liberal jurisdictions is officially finished forever today. If you want to understand exactly what this means for local gun owners, you must pay attention to these rapid developments. Your personal constitutional rights literally changed overnight due to this sweeping judicial order.
Hit that subscribe button right now, because what happens during the next 90 days will determine American civil liberties for multiple generations. This emergency legal situation involves the Supreme Court actively reviewing a case that directly challenges state authority. The justices are questioning whether local governments can require basic permits for civilian gun ownership under any circumstances whatsoever. The undeniable fact that they accepted the specific case on emergency status tells you everything about their intentions. Out of thousands of legal appeals filed every year, the High Court fast-tracks only a few select cases. This specific lawsuit represents one of those rare fast-tracked constitutional challenges today. Here is the current legal reality operating across the country before this monumental ruling effectively dismantled the restrictive state-level systems. 27 independent states already operate under constitutional carry frameworks successfully today.
Inside those free states, you never need government permission to own or carry defensive firearms for your personal safety and daily protection. However, inside the remaining 23 restricted states, citizens are forced through complex permit systems. These restrictive systems regularly cost residents anywhere between $150 to $800 just to apply legally. These local jurisdictions require weeks or even months of unnecessary waiting periods. They grant unelected government officials the unchecked power to simply deny your fundamental rights based upon entirely subjective political standards and opinions. Your fundamental constitutional rights literally depend upon which side of an invisible state border you happen to stand on today. The legal argument presented to the High Court was devastatingly simple and impossible for state lawyers to definitively refute. The determined plaintiffs told the highest court that you cannot require government permission slips.
They argued successfully that making citizens beg to exercise a constitutional right transforms that inherent right into a heavily regulated privilege. Think deeply about what we are actually accepting right now within these restricted jurisdictions. Imagine if your local governor suddenly announced you must submit a formal application and pay a $300 processing fee. Imagine taking a mandatory government class and waiting 8 long weeks for an approval letter. Imagine waiting for a local bureaucrat to decide whether you are legally allowed to attend your local church on Sunday mornings. We would immediately recognize that religious restriction is entirely insane and unconstitutional today. We understand exactly what an inherent civil right means when discussing free speech or religion, and firearms are no different whatsoever. The Second Amendment is supposed to work exactly the same way as your other rights. What forced the Supreme Court to act so urgently was that federal appeals courts started ruling in totally opposite legal directions. Several regional circuits stated that mandatory civilian permits heavily violate the United States Constitution.
Meanwhile, other liberal circuits declared that expensive civilian permits are perfectly fine and represent common-sense public safety regulations today. This massive judicial divide means identical conduct is considered a protected civil right in Texas. However, that exact same behavior instantly becomes a severe felony punishable by prison time if you cross into New York territory. The Supreme Court exists specifically to prevent exactly this kind of dangerous constitutional chaos nationwide. But nobody in the mainstream media is honestly reporting how this specific legal challenge actually reached the highest judicial level. It involves a highly disruptive lower court decision that sent shockwaves through the established legal community. The courageous judge who exposed this system did not just question certain minor permit requirements or demand faster application processing. He legally blocked an entire state permit system, declaring it blatantly unconstitutional on its face. That specific legal terminology means absolutely no amount of minor legislative reform can ever fix the underlying constitutional violations found inside. The entire restrictive permit system has to go away forever under this judicial logic. His underlying legal reasoning was straightforward, but highly explosive for politicians who rely upon these systems to disarm everyday citizens. After deeply examining extensive historical records from the founding era through the early Republic period, he found exactly zero evidence that the Founding Fathers ever required civilian permits to own or carry personal defensive firearms. People simply owned and carried their defensive firearms everywhere as a natural human right.
They did this without submitting formal applications, paying expensive government fees, or facing arbitrary, unelected gatekeepers trying to disarm them legally. Then the federal judge uncovered something highly disturbing, buried deep within the historical record today. He found evidence that modern gun control advocates absolutely never want discussed during any serious constitutional debate or public hearing. Restrictive permit systems only appeared within American law during the early 1900s. The real political motivations behind these restrictive civilian laws were explicitly racist and designed to heavily target specific, vulnerable minority communities. Southern state governments created restrictive permit schemes specifically to disarm Black Americans after Reconstruction ended. Meanwhile, Northern cities designed highly discretionary systems specifically to keep defensive weapons away from newly arriving immigrant populations they disliked. These foundational restrictions were never actually designed as legitimate public safety laws. They were always political discrimination tools dressed up as reasonable government regulations to systematically disarm groups that politicians deemed dangerous or highly undesirable. The state government immediately appealed the ruling, feeling highly confident they would eventually win. But something highly unexpected happened when the case reached the next judicial level for a standard appellate review process today. A three-judge circuit panel not only upheld the original preliminary injunction entirely, they did it with a 2-to-1 vote and wrote a blistering opinion that destroys the entire fundamental concept of permits. The prevailing majority stated that requiring permits for constitutional rights is like requiring church permits. The exact moment you make a civil right contingent upon government permission, you have unlawfully transformed it into a temporary privilege. When the losing state desperately demanded the full circuit reconsider the case, every judge declined. That serves as a powerful legal signal that the full appellate court firmly believes the original 3-judge panel got it right. This created an immediate legal crisis because other federal circuits had ruled the opposite way. The Second Circuit formally upheld the restrictive New York permit systems,
while the Ninth Circuit protected California unconstitutional laws today. Meanwhile, this specific conservative circuit declared all permits unconstitutional without any hesitation. Federal courts across the nation were saying totally contradictory things about the exact same fundamental constitutional right regarding civilian firearm ownership. But what really accelerated this specific legal case was not just conflicting lower court opinions.
What happened next at the highest federal level remains entirely unprecedented within modern American legal history and constitutional jurisprudence today. The federal intervention nobody saw coming involves the United States Department of Justice taking action. The Justice Department has officially taken a strong position on gun rights that goes further than any previous federal administration. What federal lawyers are currently arguing should terrify every anti-gun politician in America today. The Justice Department did not just say that overly restrictive state permits are problematic or require minor administrative reform soon. They directly told the Supreme Court that any civilian permit requirement whatsoever violates the Constitution. It does not matter how reasonable the law seems, it violates the Second Amendment by forcing citizens to beg for rights. Their underlying legal logic is absolutely airtight and impossible to dispute using historical facts. Fundamental constitutional rights cannot be made contingent upon receiving government approval and paying expensive processing fees under any circumstances whatsoever. Think carefully about what the federal government just argued before the highest court today. They are saying requiring permission slips before exercising your rights permanently transforms those inherent rights into easily revoked government privileges. There is simply no such thing as a constitutional privilege within the American legal framework. Something is a fundamental right you inherently possess, or it is a privilege. The Justice Department comparison is almost entirely impossible for liberal lawyers to refute in court. You do not need state permits for your free speech rights or your religious protections under the First Amendment today. You need no permits for Fourth Amendment protections against illegal searches by local police officers. You need no permits for due process rights. So why treat the Second Amendment differently than every other civil right? The federal lawyers did not just argue basic legal theory inside the courtroom today. The Justice Department presented hard statistical data that entirely destroys the common public safety argument utilized to justify restrictive permits. Texas recently implemented constitutional carry, and their violent crime rate dropped 4% immediately. Florida eliminated civilian carry permits entirely and saw a 3% decrease in violence during their very first year of implementation. These real-world numbers directly contradict the false claims that permits keep everyday people safe. And it is not just the federal government bringing this vital statistical evidence before the Supreme Court justices right now. Over 25 states with constitutional carry have filed formal legal briefs supporting this case. They are forming the largest state coalition for a gun rights case in American Supreme Court history to protect civil liberties. Tennessee eliminated their permit systems back in 2021 to restore fundamental freedoms. Since that change, violent crime dropped 7% over 2 years, proving that constitutional carry actually enhances local public safety outcomes. These conservative states are not just speculating about theories, they are reporting actual safety results. The legal briefs also expose something terrible that never gets enough attention from the mainstream media during these heated debates.
The overall cost of these permit systems is devastating for average working-class families today. Paying $800 for fees and mandatory training represents a crushing financial barrier for people living paycheck to paycheck. The vulnerable people who need self-defense the most are priced out of their rights.
People living in high-crime neighborhoods are the ones who can least afford to purchase expensive government permission to protect themselves. The corrupt system intentionally prices vulnerable populations out of their fundamental constitutional rights today. Meanwhile, wealthy politicians and elites face absolutely no financial barriers when hiring armed security teams to protect their own families. But even with all this positive legal momentum happening at the Supreme Court right now, there is something terrible happening inside liberal state capitals that could make this entire judicial victory virtually meaningless for you. The secret backdoor legislative schemes being planned right now will make you absolutely furious today. Sources inside multiple state legislatures have revealed that anti-gun politicians are already preparing unconstitutional contingency legislation to bypass rulings. These are not just theoretical backup plans being discussed in casual political meetings today. Actual restrictive bills are being drafted right now behind closed doors to strip away your rights the moment the court rules. The deceptive strategy being deployed by these liberal governors is cynically brilliant and highly coordinated. They plan to change their laws immediately after the court rules, hoping to make the original lawsuit entirely irrelevant and moot. New York successfully pulled this exact same deceptive maneuver multiple times during previous legal battles. After the Supreme Court agreed to hear a major case, New York altered their concealed carry law to dodge the ruling. California has an even more calculated plan to ignore the highest court in the land. Sources familiar with their draft legislation state they are preparing to replace formal permits with a mandatory firearm safety certification. Here's the terrible part that should infuriate every single freedom-loving American citizen today. That new certification will require the exact same background checks, expensive fees, and endless waiting periods as their current permit system. They are literally just renaming the exact same unconstitutional system and betting you will comply. New Jersey has an even more insidious scheme involving mandatory government approval for every single box of civilian ammunition purchased locally. Illinois is actively exploring legislation that would require extremely expensive mandatory liability insurance policies. This intentionally allows greedy insurance companies to price everyday working people entirely out of their fundamental right to bear defensive arms. Massachusetts is drafting complex legislation to require state-approved training courses that are impossible to find. The state wants to heavily control which instructors receive approval, intentionally restricting class availability to prevent citizens from getting certified. Every single one of these legislative workarounds shares the exact same core unconstitutional design today. Government pre-approval remains strictly enforced. Expensive fees are simply relabeled, and corrupt officials retain the power to easily deny your rights. The permit disappears in name only, while all the oppressive delays and restrictions stay active. Some legal experts believe these terrible workaround bills could be introduced within 30 days of the final Supreme Court ruling today. If you live in a free constitutional carry state, this ruling permanently protects your freedom. But if you reside in a restricted state,
Your specific situation depends entirely upon your local government willingness to actually comply. Expect immediate resistance and years of intense legal battles in places like California and New York.
Join state-level organizations right now to stay highly informed and avoid severe legal problems during this chaotic transition period.